Hello and welcome everyone to the fourth installment Ed Lab. This is education literature for accounting and finance professionals and business owners. Now, my name is Randy Blackwood, and I'm extremely excited to have you all here online with me today. Now, this is your first time joining us. What I would like to do is just go over a little logistics so that you know how to participate during the webinar. On the side, you'll see a chat box on your left-hand side where at any time, if you want to ask any questions, or even if you just want to kind of converse or respond back to an answer that we provide, definitely do so. Again, this is going to be a two-way webinar, so we want you to feel more than welcome to ask any questions at any time. Now, once again, my name is Randy Blackwood, recruiting manager for Blackwood Employment Source, Inc., where we help top businesses help hire talent. Now, on today's webinar, I will be sharing the platform with my good friend and colleague, Randy I. A little quick background on Randy. He is the founder of Randy I Law Practices, a boutique labor and employment law firm in downtown Toronto district. He specializes in assisting both employer and employees in areas of labor and employment law, such as wrong dismissal, constructive dismissal, employment contract, legislation, workplace harassment, human rights, unification issues, as well as workplace disability and WSIB. He holds a law degree from Osgoode Hall Law School, in addition to having a Bachelor of Health and Science from the McMaster University. He is a skilled advocate and experienced representing clients before a wide range of courts and tribunals, such as the Federal Court of Appeal, the Ontario Supreme Court of Justice, the Canadian Industrial Relationship Board, and the Ontario Labor Relationship Board. Now, through Randy's journey, he was able to work for various firms. Now, a few of them would be Berinsky, Vassals, Henderson, Davies, Howes Partners, as well as Ontario Ministry of Labor and Parkdale Legal Clinic. So without any further ado, I would like to everybody give a warm welcome to my good friend and colleague, Randy I. Randy, can you hear me there?
I can hear you. Randy, can you hear me?
I can hear you loud and clear. How are you doing, Randy?
Amazing. I'm doing very well. First of all, it's great to be presenting with someone with the same name. So those of you may know that Randy is not the most common name, and it's great to share a name with someone else. And so just by way of background, my name is Randy I. I am the principal lawyer of Randy I Law Office. It's a labor and employment boutique in downtown Toronto. I specialize in assisting both employers and employees with all aspects of workplace law. So that includes wrongful dismissals, constructive dismissals, workplace policies, termination, severance, and human rights. And I'm very excited to be presenting to you today.
Perfect. Thank you again for giving us a little bit more background on you. Now, Randy, let's get started. The purpose of today's webinar is to help employees become aware of their rights and options that are out there for them. And basically, we're going to be able to do this by, this will be achieved by understanding the new developments in employment law and legislation, the 5 common issues employees face on a daily basis, employees' rights and actions they must take, and how to select the right employment lawyer to represent them, as well as other various questions. As you and I have spoken, Randy, I've been getting influx of questions that candidates and employees are dying to kind of get off their chest. So before we kind of dive into that, can you give me a little bit more of what an employment lawyer is and what they do?
Well, an employment lawyer helps individuals and companies with all of the law that relates to the workplace. And the very fascinating thing about the workplace is that there are many laws that one must adhere to. There's something called the common law, which is what the courts would say. There is the Employment Standards Act, which is the minimum requirement that that govern the workplace here in Ontario. And many of you may be familiar with the Employment Standards Act, which gives us things such as overtime pay, termination pay, minimum wage, these types of things. And there are many other pieces of law that intersect in the workplace. For example, the Human Rights Code, there's WSIB, which is workplace injury issues, and much more.
Perfect, perfect. Now, you did touch on one of the common, which is the common issues that employees are faced on a daily basis. What would be some of the common issues, Randy?
Well, I think termination would be a big issue. A lot of employees in Ontario, unfortunately, are let go, and I see this on a day-to-day basis at my office. So that's going to be a big issue. There's issues of harassment that employees are going to face. There's issues with respect to performance improvement and discipline, and there's legal ramifications for these types of issues. And many other issues that sometimes are law related and also sometimes are human resources related. For example, employee relations, how an employee relates to other employees, and what are some of their rights vis-a-vis each other.
Oh, perfect, perfect. Now, Randy, as an employee, what are some of their legal rights if they were fired without cause?
Well, just to explain what without cause termination is, the employer has the right to terminate an employee in Ontario on a without cause basis. And this is also called wrongful dismissal. Now, many employees may say, well, that's not fair. How come I got terminated? Well, as long as there's no just cause, which is a concept I will explain later in this presentation, unfortunately, the employer can terminate you at any time. But that being said, the employer must also give you a severance package. And a lot of what I do is I help employees figure out, well, what is that severance package?
Perfect, perfect. Which I take it that we're going to dive into a little bit more in the conversation.
Exactly. So the next question is, if you see the next question on the slide is, oh, what is my severance package? Do I know if I received the right one? So going back to the idea of without cause dismissal, the moment you're dismissed without cause, you should be receiving a severance package. And severance exists on a spectrum. There is the lower end of the spectrum, which is the Employment Standards Act, and that's what the Ontario government says is the very minimum. And how that works is you get termination pay of approximately 1 week per year, and that sort of stops at 8 weeks. And then there's something called severance pay, which you are entitled to if the company has a payroll of more than $2.5 million, and if you've worked for the company for more than 5 years. So under basic employment standards, you would receive a maximum of 2 weeks per year. Another way to calculate severance is by way of your employment contract. So you would go back to your original job offer or employment contract and see what it says with respect to your severance package. And that could be 2 weeks per year, 3 weeks per year, 4 weeks per year. You would follow the terms of the contract. Now, if the contract is silent or you don't have a contract with respect to severance, then you look at something called common law. And common law is what essentially the courts would say if the case were to ever go before a judge. And the courts generally would say that the employee is entitled to 1 month per year, which is a lot higher than the 1 week per year minimum that you often would get under employment standards. And common law could be even higher than that. I've seen some employees, for example, working for a couple of years to get more than 1 month per year, because there are a number of factors that go into the calculation of severance. And these factors include the employee's age, their length of service, their specialization, their education, their seniority, and essentially how hard it is for them to get another job in the same or similar industries.
Definitely a wide range. Now, another question that I was approached with was, what are my legal rights if I'm fired with just cause?
So just to explain what that is, just cause is a very high threshold. It means that the employee generally has engaged in some type of misconduct or has done something. Yeah, I heard the question. Or they've done something that repudiated the employment relationship. So just cause often means misconduct, dishonesty, sexual harassment of other employees. It could mean insubordination. It could mean abandonment of your employment. And in some extreme cases, very, very poor performance. But the performance has to be of such a poor standard that the employer can no longer have you in the workplace. That if the employee is terminated for just cause under the law, then they are not entitled to a severance package, and they may be requested by the employer to leave the premises immediately.
Perfect. Now, is that common that you'd see employees face the unjust cause, or more like more of the cause?
Well, I would say that 90% of the terminations that I see.
Did you hear my question?
I did. I would say that 90% of the terminations that I see are without cause, and then 10% are on a cause basis. But often the employer will allege cause where, in fact, a cause may not have existed. So to put the statistics in perspective, the actual number of people being fired for real just cause is probably about 1 in 20 in Ontario.
Perfect, perfect. That's a clear understanding. Now, another question that I was approached with was, is constructive dismissal?
Well, Randy, constructive dismissal is when the employer changes the terms of your employment without your consent. So I will explain what that means. Suppose you have a person who is an executive person. Suddenly the employer has you serving coffee, right? Your job description has changed without your consent. That could be constructive dismissal. Or if there's a decrease in your salary without your consent. So for example, you're earning 100,000 and suddenly it turns into 85,000 and you didn't consent to it. Or they relocate you to a completely different place. Or they change some other aspect of your employment conditions that were expected. This constitutes constructive dismissal. And what does that mean legally? It means the action is as if the employer had terminated you. So when a constructive dismissal occurs, the employee is entitled to a severance package and is entitled to end the relationship with the employer. And one final example of constructive dismissal could occur in a harassment or bullying work environment, where the work environment is so poisoned that the employee actually cannot go back to work. And that could constitute constructive dismissal as well.
Clear understanding. Because I've seen it on your profile, and I just wanted to get a clear understanding of that. Now, Randy, I work with accounting professionals, and we have a few of them on line with us today. Generally, their salary is typically anywhere from 80 to 6 figures. Now, they are getting paid an annual salary. Are they still entitled to get overtime?
Well, accountants and lawyers and doctors and dentists, there are certain types of professions that are not entitled to overtime pay by way of the statute. So the Employment Standards Act will preclude certain professionals from receiving overtime. So that's the first thing that I need to say. But if you're talking about a general worker who is non-management, so that they're not hiring or firing other people, but a salaried worker, then yes, they would receive overtime pay as long as they work more than 44 hours per week. Now, that's what the law says. So after 44 hours, you get time and a half. Even if you're a salaried employee, you would still receive that overtime pay.
Perfect, perfect. Now, the following question to that is, how many letters of warning can an employee get before they are fired?
Well, in a without cause termination, again, in a wrongful dismissal type scenario, it may not be any letters of warning. You may just be called into the office one day and there's an HR person waiting for you, and you get your letter of termination and a proposed severance package. So there's no obligation to give you warning letters prior to the termination itself. However, if it's a for-cause dismissal and the employer is alleging cause specifically based on poor performance, then for the just cause to be upheld at law, there needs to be a number of letters of warning given to the employee, and the employee needs to have been given an opportunity to improve. So you just can't terminate someone for just cause by saying you're a poor performer. You have to give them a number of warning letters, perhaps put them on a performance improvement plan, and give them an opportunity to improve. If they haven't improved or if they've gotten worse, then perhaps that would justify a cause dismissal.
Now, Randy, I was recently speaking with an employee, and they were kind of just, I guess, indicating that their employer was questioning or asked questions about their insurance. So the question that they asked me was, they said, can my employer cancel or modify my insurance or pension benefit?
Well, the circumstances of canceling or modifying insurance benefits could lead to a constructive dismissal, which is a concept we discussed earlier in today's presentation. If the employee has always received insurance benefits or pension benefits and they were suddenly removed, for example, 5 years into the employment relationship, I would say that it almost certainly constitutes a constructive dismissal, and that would be illegal for the employer to do. Now, on the other hand, if the employee never had insurance benefits and never had pension benefits, then that's a different story because nothing has been removed and the employer hasn't done anything unilaterally without the employee's consent.
Okay, perfect. Definitely allow me to clarify that with them. Now, Randy, another following question is, as an employee, are they protected by the Ontario Right Code at work? Ontario Human Rights Code at work?
Absolutely, Randy. The Ontario Human Rights Code protects employees and it prevents employers and other people at the workplace from discriminating against people based on the enumerated grounds of the Ontario Human Rights Code. And the grounds, for example, are disability, age, gender, race, ethnicity, religion, criminal record, place of origin, sexual orientation, and many others. They also include family status, which is your obligation towards dependents, and some other human rights codes. So the employer is, first of all, prevented from discriminating. So you can't fire an employee based on their age or their ethnic background if the termination was in fact related to that protected ground. And the employer is entitled, or rather, the employer is obligated to accommodate the employee. So if the employee has a disability, they can ask for accommodation from the employer, and the employer has to accommodate the employee to a point of undue hardship. They essentially must try their best to accommodate the employee to a point where they say, anymore, and we cannot realistically do that. And that's the point of undue hardship.
All right, let's move a little bit into harassment. I've had a colleague actually turn to me and say, what do I do if my employer is harassing me?
Well, there are a number of things that we can do if the employee is being harassed. So there's several ways that you can think about the problem. First of all, often in larger companies, there is an internal complaint process through HR or employee relations that you can access. So the manager who's harassing you may be violating the company's own internal policies. And often there is a pathway to addressing that internally by way of a complaint, perhaps a formal complaint to HR, and then you would follow the procedure internally. Another remedy is the Occupational Health and Safety Act. So there is an anti-bullying provision of the Occupational Health and Safety Act that prevents workplace bullying. So if the manager is bullying the employee, so that could be verbal bullying, sexual bullying, it could be physical threats, intimidation, anything that constitutes bullying, then the employee can go to the Ministry of Labor and ask for an investigator to look into the issue. And there may be circumstances where the bullying is so bad that prosecution may even be a viable option. And then there is the human rights aspect of it. So if the manager is harassing the employee for one of the prohibited grounds under the Human Rights Code, so for example, if the manager is harassing the employee because of their gender, So perhaps a male manager harassing a female employee, that could be a human rights violation. And then the recourse would be the Ontario Human Rights Tribunal, and you could submit an application to the tribunal for the harassing behavior.
Perfect, perfect. I'm just turning to our social media for a second because I did see a question come in when you were mentioning the internal complaint process. Louise was asking, is this process easily found or accessed? So I'm assuming she's wondering, how would you find out that information at work? Like, would you talk to your manager? Would you go to HR?
Often in larger companies, and Louise, it depends on how big your company is. So smaller companies may not have a policy in place with respect to harassment. So suppose you work at an organization with 10 people, the senior partner or the person who owns the company is the person who runs the show. There may not be an internal process available because the company is too small. But I would say for most companies over 100 employees, where they're a large company, a large bank, a large insurance company, these types of organizations always have an internal policy in place. One of the first places that you can access this recourse is through human resources. So speaking with the human resources individual at your company or speaking with the employee relations officer. That can help you access the internal channels by which you can make a complaint. One of the other ways is perhaps speaking with your direct supervisor, assuming that the direct supervisor is not the person harassing you. If that is the case, obviously that's not the right idea. But if someone else is harassing you, then the direct supervisor may be the person to speak to, and they can help you escalate it to the correct person within the organization.
Now, Randy, we're going to kind of move into leaves of absence. So let's say an employer, is the employer entitled to giving an employee back their job once they leave on either maternity leave or parental leave?
Well, maternity leaves and parental leaves are job protected under the Human Rights Code. And so, for example, if a female employee goes on maternity leave and returns 9 months later, the employer cannot remove their job and have them do something else, or they can't fire them for the basis of their maternity or their pregnancy. So it is job protected. And if a person returns from maternity leave and finds that, one, they've been fired, or two, their job has changed substantially and that they're no longer doing what they used to do, and that was a unilateral change by the employer, and the employee did not consent to that change, then we have perhaps a human rights violation or a constructive dismissal, and the individual would definitely have a right to sue the company under the law.
Now, Randy, I'm positive I read somewhere that it mentioned the employer is entitled to modify the duties. Is that legal, or is that? Because I know I read something on the line. Go ahead.
Yeah, the employer can modify duties within reason and within discretion. So if you have a job as an account manager and they've given you certain new duties or assigned new clients, or perhaps are challenging you in a particular way to look in a geographic region for where the clients are coming from, something like that's fine. But if they change your job entirely, so if you're an account manager and suddenly they have you doing secretarial work, that's inappropriate because the change has been drastic. And again, with everything in law, there's always shades of gray, that it's not a black or white answer. It would depend on what they do with your new job and how significantly it's changed from your old job description.
Perfect, perfect. All right, so moving down the list here. The next following question we have here is, can I be transferred without consent?
Well, with respect to this question, it again depends on how far you're being transferred and whether the employer is assisting with the transfer. So in some circumstances, a transfer can be a constructive dismissal, in that if you were working in one office and now the employer is forcing you to travel to Vancouver for a new position without your consent, that could be a constructive dismissal. But if the employer is saying, well, we're transferring you from one plant to the other, so if, for example, you're working at one factory in the downtown Toronto area, and that factory closes, and the employer now wants you to be in the uptown area, or perhaps in Scarborough, that may not be a constructive dismissal because the burden on the employee is not severe enough to constitute a violation of their rights. So again, it depends on how they're transferred, how far they're transferred, and often if the employer shows some good faith, that could facilitate the transition. So I often see good employers, what they would do is help you with your transportation. So suppose employees cannot travel to the location, perhaps the employer will arrange a pickup with a bus, or will subsidize the employee for mileage or for taxi costs to facilitate the transfer. Something like that can be worked out between the employer and the employee can help maintain that relationship so that both parties are happy.
Perfect, perfect. And Randy, we did get another question in regards to the, just go there for a second. Here we go. We did get a question in regards to the harassment. Do you mind if we just touch back on the question?
Yeah, of course. No problem.
Would that be fine?
Yeah, go ahead.
So the question that Lisa actually threw out is there a fee to start the process to investigate the claims?
All right. So if this is with respect to a harassment claim, if you're talking about, Lisa, if you're talking about an internal harassment investigation, then no, there shouldn't be a fee.
Can you hear me?
Yeah.
The question was, is there a fee to start the process to investigate the claims?
Well, as I said, there's
This was when
if it's internal, then no, because the company should be taking care of that. And if the company is doing their job, they should be investigating the complaint of harassment internally, and it would be completely inappropriate for the company to be charging the employee a fee. Now, the company may incur a fee for hiring external investigators if they want a workplace investigation. We saw that, for example, with the Jian Ganeshi case, where CBC had retained the services of an external law firm to conduct the investigation. So the employer, again, may incur the fee, but the fee should never be put on the employee. So the person complaining of the harassment should never be charged the fee.
Sorry, Randy, it looks like we just had a little bit of technical difficulties on that last response. Is it possible that you can just repeat that one more time for me? Had a little bit of technical difficulties.
No problem. Let me just repeat my answer, which is that the employee, I can hear you, which is that the employee should never be charged the fee for the investigation. Yeah, the employee should never be charged the fee for the investigation, which is the answer to Lisa's question.
Perfect. All right, so moving down to the next question we had on hand. Can an employee refuse to work because of certain working conditions?
Absolutely. If there are safety issues in the workplace, for example, if there's asbestos in the workplace, so if there's safety issues in the workplace, asbestos, unsafe workplace, then absolutely the employee under the Occupational Health and Safety Act can choose not to work and can make a complaint to the Ministry of Labor and to say that the workplace is unsafe. If the working conditions relate to a poison work environment, that's to say it's not the physical environment that's unsafe, but the employee is being harassed by employees or the employer or other people in the workplace, then they could also declare that the workplace is unsafe for them because they're being bullied. And that may be covered under the bullying provisions of the Occupational Health and Safety Act. So let me give you this example. If you're going to work every day and your manager is physically threatening you, that would cause an unsafe work condition, and you are entitled to refuse to go to work in those circumstances.
Sorry, Randy. It looks again like we had some technical difficulties. I heard the last part when you mentioned if you were attending work.
Yeah. So as I said, if you were attending work and there was someone harassing you or bullying you at work, that could create a safety condition where the worker no longer feels safe, and that would be a violation of the Occupational Health and Safety Act under the anti-bullying provisions. So the employee can refuse to go to work if they're being bullied or harassed by other individuals.
Perfect, perfect. Thank you again for repeating that. Now, moving on down the list, we have just a few more questions that we want to cover. I know that people keep actually sending them in through social media, but we'll definitely respond back to a few of them shortly. Now, can an employee be fired if they are off on sick leave for a prolonged period?
Well, the short answer is no. If they are fired, then that would be a violation of the Human Rights Code, because usually when an employee is sick for a long period of time, they're also disabled. So if the employee is fired for being disabled, then that's a human rights violation. An employer would be foolish to fire an employee for being sick for a long period of time. Now, however, if the employee is sick for such a long period of time that there is no chance of them ever returning back to the workplace, that could mean something called frustration of contract. That means the employer and the employee can say that the employment contract between the two, has essentially ended because the employee can never go back. So the employer may declare that and say that by way of frustration of contract, they could end the employment relationship. But as long as the employee has an opportunity or physically could potentially at some time go back to the employer and continue with their work, it's not recommended for the employer to fire the employee for being sick.
Perfect, perfect. All right, I'm just turning back to social media for a moment here. I have John mentioning the sheer fact of what would the time frame look like for a frustration of contract. John Snow asking what would the time frame look like for being frustration of contract.
Well, John, it would have to be a significant period of time. So if the employee is sick for 2 years, and suppose they're on short-term, or I guess in that case it would be long-term disability. If they're on disability leave, then absolutely not. The employer cannot just fire the employee if they're on disability leave, if they're sick, especially if they have medical notes. And that's the key. If they have a medical note from a doctor that says this employee cannot return to the workplace, then they just have to be still an employee on payroll. They may not be receiving any salary, but they would still be an employee on the books until they either return or they quit or they find a new job. So I've seen cases where employees stay on the books for 4 years, 5 years, as long as there's a chance that they will return. But if you have a medical note that says, well, this employee can never go back to work, that they are disabled for the rest of their lives, then we may have a situation where there is a frustration of contract because the employer would say, well, it's not fair for us to continue with these benefits for the rest of your life because the employee can never come back. So again, it's contextual, but if the employer can reasonably foresee the employee coming back, then they can't fire the employee. But if the employee cannot reasonably come back ever again, that could constitute a frustration of contract.
Perfect, perfect. Moving down with the questions. What are some new developments in employment law?
Well, one thing that I find quite exciting is reasonable notice periods. So what that means is generally the courts in Ontario have said that the maximum amount of severance the employer will receive upon termination without cause is 24 months, or approximately 2 years. Now that's been stretched to, in some cases, 26 months. So we're seeing an increased notice period. We're seeing employees, especially older employees near retirement age, getting more money from the courts when they have these wrongful dismissal cases. So that's a very exciting development for me in employment law, because we're seeing the courts recognize longer terms of service. We're seeing the courts recognize that older employees may not be able to find another job ever again, and that this severance is essentially the retirement package, especially in cases where the employee may not have a pension plan. And there are many instances now where pension plans don't exist for certain employees because the nature and the structure of the workplace has changed. So again, longer notice periods, I think, is a very refreshing development. One of the other things that I want to mention is the emphasis on family status. This is a new development that I've been seeing in employment law as well, and that's where the human rights tribunals are recognizing that an employee's obligations towards their dependents is something to be protected. So, for example, if there's an employee who needs to leave at 4 o'clock every single day because they need to pick up their kids from daycare, and otherwise the child doesn't have any caregivers, that could be a grounds for accommodation. So the employee could actually go to the employer and say, I need to leave at 4 to pick up my kid, and the employer will have to accommodate the employee in those circumstances.
Perfect, perfect. Now, I know I skipped over one question, so I'm going to just follow back with it. And it says, what does employment at will really mean?
Well, employment at will is an American concept. In Canada, we don't have this concept known as employment at will. What it means in the American context is that an employer could terminate an employee at any time without giving them any severance or termination pay, and conversely, the employee can quit and resign without giving any notice to the employer. So it's a complete free-for-all that we see often in some American states where you can hire and fire and everything happens without termination pay. That's not the case here in Canada. In every province, minimum statutory obligations exist where the employer will have to give the employee some type of termination pay or severance pay as long as the employee has met the probationary period. And the probationary period is usually 3 months. So any employee in Canada that's worked for more than 3 months at a particular employer should be given at least some minimal termination or severance pay, which is not the case in the States.
Now, Randy, we've been touching several different practices, several different laws, even some changes that will be happening in the near future. Now, I know our listeners are sitting back and saying, well, how do we make that right decision on finding that right employer to work with? So what are some of the suggestions that you would have for finding and selecting the right lawyer to represent them?
Well, often the cases that I deal with are wrongful dismissal cases or constructive dismissal cases. The most common 2 scenarios where an employee comes to me for help is, one, they feel that the employer is harassing them in some way, or there's circumstances in the workplace that make it impossible for them to go back. So that's the first scenario. They're just very unhappy with their workplace. And second is when they're fired. And that could be for cause or without cause. They've been terminated. They come to me with a severance package. So to answer your question, Randy, a good way to identify the right employment lawyer you want to work with, one is to research them a bit. So go online. Everything's online these days. Look at the credentials. Look at the employment lawyer that you want to work with, and see if this is someone that you actually want to work with, and this is someone that you want to put your trust in. Then something that I do is I always offer free telephone consultations. It's never a bad idea to call up the lawyer and to speak to them for 5 to 10 minutes and see if they know their stuff. And you can tell a lot about a person by just speaking to them for 5 to 10 minutes over the telephone. So all of my new clients, when they call me, they usually have a telephone conversation with me. And after that telephone conversation, we can see if we want to work with each other, because Again, it's a partnership with your lawyer. You want someone who is good at what they do and who can represent you. At the same time, I want clients who are also cooperative. I don't want clients that believe that they can get $50 million when the case is only worth $10,000. So there's again there needs to be cooperation with the lawyer and with the client, and it's a team-based exercise.
Perfect, perfect, perfect. Again, Randy, you've provided a wealth load of knowledge throughout this whole practice, and even just breaking down how to find the right or identify the right lawyer to kind of help and proceed forward. I know that time is coming to an end, and some of the questions are still slowly filtering in. I'm just waiting to get more feedback from my tech person for social media, because I know that we had a couple of questions still on social media. Randy, do you mind just hanging around for a few more minutes, just kind of answer more questions?
Yep, I'm here.
Yeah? Okay. All right, perfect. So before we jump into some of the questions with the social media, I did want to give the audience an opportunity to kind of reach out to you, right, Randy? Like if there was an opportunity how to connect with you, what would be the best way to connect directly with you?
Well, one way is to go to my website. It's very simple. It's just randyi.com. So RANDYAI.com. AI is my last name, so it's just my first name and last name.com. My office number you can see at the bottom of the slide, which is 416-716-2256. Also, you can always contact me by way of email, and my email is randy@randYAI.com. So again, it's my first name at firstname@firstnamelastname.com. So any of these ways, you can contact me directly, and either myself or a member of my team will get back to you.
Perfect, perfect. And for being on this webinar today, we did chat a little bit. You were mentioning that there would be that initial free consultation just to kind of see if it's a good fit. As you mentioned, you always want to make sure that you're working with somebody who you can kind of get along with and who is willing to kind of listen, and as well as provide the right information for you so that you can work on their case, right?
Absolutely. So again, as I said earlier, I offer free telephone consultations. So anyone who wants to call me up and just discuss their case in general, I'd be happy to do that. And then the next stage is a more in-depth consultation at my office, and that's a charged consultation in that there's a fee involved with that consultation, and that usually lasts between an hour to 90 minutes, and that's charged at a flat rate.
Okay, perfect, perfect, perfect. Just reaching out to Twitter, I see here. I got @JB she's asking, are you connected on LinkedIn? If she can reach out to you on LinkedIn.
Absolutely. If you search my name, Randy I on LinkedIn, you'll see Randy I, Law Office, Toronto Employment Lawyers. I should be the only one there. So if you want to find me on LinkedIn, then by all means, please do.
Perfect, perfect. It's been a blast having you online with me today. I do hope that all of our listeners were able to take in the breadth of knowledge that you provided. Again, we're just skimming the topic and skimming the whole law practice. There's so much more to really find out, and the best way to do that is to connect with Randy. He is a veteran he has experience and a wealth of knowledge. You mentioned there's several different ways how to connect to him and reach out to him, so definitely reach out to Randy and gather some more information as well.
Great, and I just put a little comment there.
With that being said, okay, perfect. So with that being said, I think we're going to be coming to an end. Again, Randy, it's been a blast. Thank you so much for. Oh, hold on. I think I'm having one more question coming in here. Oh, very informative. Thank you. So Lisa said, very informative. Thank you. Okay.
Thank you, Lisa.
John said thank you on social media. All right.
Thank you, John.
Perfect. Perfect. Oh, Sean said thank you. Let me see if John's still there too. Yeah, John showing thumbs up. Okay, perfect. Again, Randy's here to connect with, so please don't hesitate to reach out to Randy Law Office Practices. Okay. Again, Randy, thank you for connecting with me and doing this webinar. I do appreciate it. I look forward to doing a few more with you in the near future and kind of provide more information to employees about the different struggles that they're faced with.
Well, thank you, Randy.
That solution.
I appreciate that. Thank you very much.
And Randy, for everything and being online. No
Okay,
problem.
great.
Anything you want to kind of leave our listeners with?
Well, just be informed of your rights, which is very important. Employees do have rights in the workplace, and make sure that if you're confused about something, do speak with a lawyer to be educated. And education is the most powerful tool that you'll have.
Definitely. Thanks again, Randy, for being online. Again, if you want to connect with Randy, it's Randy I Law Office. His number is there, or you can just reach out to him directly at randy@randyai.com. You can check him out on his website there. Thanks again, Randy, for being on the line. Again, thank you everyone for being on the line with us today for another information session with the Ed Labs from the Blackwood Employment Source, Inc. My name is Randy Blackwood. I look forward to connecting with you guys again soon. Again, make sure that everything you do in life is going to be productive and positive. Thanks again for being online, and look forward to talking to you guys again soon. Bye for now. See you later, Randy. Thank you.
Bye.